simply start alphabetically, and I believe we'll start with Jennifer.
It's best to stand or? Okay. Thank you, everyone. My name is Jennifer Forbes. I am running for Kitsap County Superior Court. I'm honored to stand here today as the most called upon, trusted pro tem judge in Kitsap County. I have more than 1,000 hours of time on the bench, and as I stand here for the last 7 years, I've accrued more time on the bench than all of my fine appointments put together. A little bit about myself. I come from a single-parent family. My mother struggled to put us through school as a single parent. She put herself through college. And what this taught me was about what hard work really means and how important it is to have a good education. When I was 9 years old, my father died, and we were actually so impoverished that we reached the point of homelessness for a period of time and had to live out of our car. My whole life, I've had to work hard to achieve everything that I have gained so far, and I will continue to take that and work hard as a Kitsap County Superior Court judge. I have a broad range of current experience. I was prosecutor for 10 years, where I handled every type of criminal offense there is. I handled juvenile offenses all the way to serious violent offenses. I was assigned to the Special Assault Unit, handling rapes and homicides for a period of time. I handled a number of homicide cases as a prosecutor. I have 16 years of criminal experience, the first 10 of which was as a prosecutor, the last 6 doing some private work. I also have 9 years of civil experience, handling complex civil litigation in both state and federal court. I'm a true trial attorney with both civil and criminal experience, having had over 100 jury trials. I am the only candidate up here who actually currently practices both civil and criminal law in Kitsap County Superior Court. I also understand the importance of community involvement. Judicial candidates, judicial officers are not just people to put on a robe and stand up on a bench. It's important to remember that you're a public servant. I've dedicated 16 years to this community, giving back to the community in a variety of areas, including the Red Cross and a variety of youth-oriented programs. I'm also the president of the Kitsap County Bar Association. I'm the only candidate who stands up here today who's rated exceptionally well qualified by more than one bar association. And it's not just one, it's not just 2, it's not 3, it's 4 different bar associations. I have nearly 400 endorsements, including Derek Kilmer, Larry Sequist, and a number of other individuals on both sides of the party lines. I'm endorsed by 19 judges, 17 of which are your local judges. These are judges who know our courts, know the needs of our court, and happen to know all 4 of the candidates. And these judges have endorsed me for this office. I offer these endorsements not as a rubber stamp for my qualifications. I know that it doesn't just mean that. But what it means is that those who know me, the attorneys who practiced against me, the members of the community who've gotten to know me over the years, know that I'm the right candidate for this position. I'm Jennifer Forbes, and I would love to have your support.
Good morning. My name is Bill Hauser. I presently serve the county, Kitsap County, as a member of the Public Defender's Division Office as a public defender in our county. My caseload right now is a felony caseload at Superior Court. Every day that I go to work, I go to the Superior Court to practice law. My felony caseload runs between 120 to 150 cases per year that I handle. In fact, at 8:30, as we end this, I should be actually in our district court with our FIBU process, but I will not be there. Someone's going to be covering for that. And later on this morning, I have motions in front of Judge Lori on a felony case that we're going to be handling, I think at 9:30 we're going to start. So there are some time constraints on all of us, I'm sure. But beyond the fact that I'm a public defender in the county, I have experience of about 29 years as a lawyer, and of those 29 years, 16 years I served in private practice, either as a sole practitioner or as a member of a small firm, an owner of a small firm. My firm that I was a shareholder of, myself and another attorney partner, we had up to 6 attorneys at one time. We know that I know the responsibilities of making sure the payroll gets paid, that there's accounts receivable and accounts money that's going out of the law firm. So 16 years of private practice. And during that 16 years of private practice, I handled a small town practice. I handled certainly criminal defense, which is probably the things that I've done the most. In fact, in Oregon, this was in Oregon that I worked in this law firm. I became a death qualified defense attorney. I've handled 4 death penalty cases in the state of Oregon. I've handled divorces, family law cases. I've handled probates, wills, elder law. I've handled personal injury. All those things that you might see come to a Superior Court judge to handle. I have handled those areas. Now, beyond that, things as far as practice that frankly were fun. I was a pro tem judge. I was appointed by the Oregon Supreme Court to be a circuit court judge pro tem. And during the time the 6 years that I was a pro tem judge, I served in 6 different counties handling all sorts of different types of cases, from the most complex litigation of employment law or wrongful death as a trial judge. I also handled criminal calendars, motions to suppress, family law cases, mental commitment hearings, the type of cases that I would see as a Superior Court judge over a 6-year period of time. During that time also, I was appointed by our circuit judges as the juvenile referee of my county. That's a part-time job, it wasn't a full-time job by any means. But during that time, I helped adjudicate violations and misdemeanors for young people who were in trouble. During that time, we were able to put together what we call the Juvenile Violations Court. We tried to divert some of the kids with 3 different types of violations into a program of education and treatment. We were very successful. We were not only able to get those kids into that education and treatment program, but we were also to resolve the caseload backlog. Thank you very much. I got my yellow paddle, so I'm going to sit down now. Thank you.
Thank you, Karen, please.
Good morning, I'm Karen Klein, and I am running for Superior Court for Kitsap County because I have a passion for justice, a love of the law, and a passion for our community, and wish to join those passions and skills to serve as your next Superior Court judge, administering justice and ensuring that everyone has an opportunity to be heard. I've been an attorney for 30 years, and in that 30 years, I have a diverse skill set. I was a criminal defense lawyer for over 20 years, representing thousands of individuals, from wealthy businessmen on complex fraud in federal court to simple assault. I've tried over 75 felony jury trials in state and federal court. In addition to being a criminal defense and trial lawyer, I've been an employment lawyer. After having my own practice for 10 years in Seattle, I then became general counsel for the largest multimedia publishing company in the country, located in Bremerton, Topics Entertainment, where I was responsible for managing all outside litigation, all legal advice, including contracts, commercial transactions, intellectual property. I set up the Human Resources Department and managed all of the legal matters in that. Those are all skills which will help me understand and appreciate the business and corporate people who have come before the court. As a trial attorney, I have skills that will help me manage the trial court more efficiently. In addition to my diverse civil and criminal trial practice and my corporate experience, I've also taught at the University of Washington Law School, as well as been a pro tem judge both in Superior and District Court in Washington State. Not only do I have diverse legal experience, I also have commitment to this community where I've lived for 28 years, serving on boards such as the YWCA for 5 years, so I'm happy if I have to give a donation, I'm glad to do so. In addition to, I currently sit on the Washington Women Lawyers State Board, the Kitsap County Health Priorities, which is a combination of United Way Harrison and the Health District, where we are working to ensure access to health care for all in Kitsap County, particularly those under and uninsured. In addition, I volunteer at Squamish Rolling Readers, teaching kindergartners to read. So my commitment to our community is long-standing. I also run a business in Kitsap County, so I understand working with seniors, and that will shows me an understanding of the people who I will be there to serve. I'm proud to say my campaign is co-chaired by the Honorable Faith Ireland, former Justice of our Washington State Supreme Court, and Carrie Bozeman, former Mayor. Thank you.
Good morning. Thank you for allowing me to introduce myself. My name is Rob McDermott. I too am a candidate for Kitsap County Superior Court Judge, Department 7. If you'd like to learn more about my background, go to robmcdermottforjudge.com. I believe I am the best candidate for this position. The reason why is I simply have more experience. Whatever metric you use to measure experience, I have more. I have more experience as a lawyer. I've been a lawyer in Kitsap County since 1982. I have more experience as a judicial officer. I have been a Superior Court arbitrator for over 20 years. The Superior Court arbitrator acts as an independent judge, deciding everything that a judge would in a case. Decides rules, what evidence comes in, what evidence does not come in. decides procedural matters and ultimately decides the outcome of the case. I've served on this district court as a judge pro tem for over 6 years. But I also have a very substantial life experience that goes beyond the legal profession. I'm a Navy veteran with 27 years of combined active duty and reserve service. I worked in the real estate industry for 4 years. And I'm a father who's successfully raised a family. I also have substantial background in community service in Kitsap County. I have a record of community service that stretches over 30 years. And if you go to my website, rodmcdermottforjudge.com, you'll learn more about it. But just to highlight a few items. For 10 years, I served with the Community Resource Center, which is a nonprofit organization in Bremerton designed to encourage the economic enfranchisement of people of color and disadvantaged. I served alongside Pastor Larry Robertson, or now Bishop Larry Robertson, for 10 years and was the co-chair of that board for 2 years. I served on the Economic Alliance board for 4 years, and I was a volunteer and a member of that organization for 15 years. I served on the United Way board for over 6 years, and I have a record that goes back 30 years in Kitsap County. From all this life experience, I believe that I've gained some wisdom that you can only get from having had all this experience. And so I think that I'm the best candidate for this position. I'm proud to, throughout my legal career, I have shown that I have the economic strength. I have the intellectual horsepower to be a good judge. I've handled some very complex litigation, and I've demonstrated I have the intellectual tools to do this job. I'm proud to announce that I've been endorsed by Sheriff Steve Boyer, who is a campaign co-chair, and Bishop Larry Robertson. And thank you for your time.
Thank you. All right, now we'll move on to the question and answer period. Again, you'll have 1 minute.
That's my They're welcome.
Anyways, it's voluntary, so no one will be tracking down on this one. With that, we're going to jump right into it. The audience here is actually pretty sharp this morning, much sharper than I could even try to imagine myself trying to come up with some of these questions. So with that, we're just going to no softball. Okay, they're just going to jump right into it. And Bill, you get to start off. And I will re-ask the question at your request, so these questions are somewhat long or complicated. And the first question is the U.S. Constitution and the Washington Constitution a living document subject to change by the times, or a reference upon which we are ruled and changed only by amendment? Bill?
Well, the Constitution should stand up because I know my voice doesn't carry well. The Constitutions, both of the state of Washington and the United States, are written documents. They're words. What do those words mean? That's really the question that comes to it. How do we interpret that? How do we apply the Constitution to the facts that we find ourselves in the courtroom today? And so it's not really the Constitution that you have to worry about, it's the facts that you have to worry about. Did the framers of the Constitution understand that GPS would be used on a vehicle without someone's permission? GPS didn't exist then. We have to determine whether GPS would be a search or not. Because the Constitution says what it says about searches. But the founders didn't know what GPS was. Now we have to deal with that. In that regard, and I believe that this is sort of where we're coming from as far as the question is concerned, in that regard, we have to take a look at the Constitution as it's written and apply those facts and find out, is that a search or not? Now, that is sort of how I interpret that question. That's the answer that I'll give. You can figure out from there. How's that? Thank you.
Thank you. Garrett?
Thank you. The Constitution, I believe, is a living document. Women didn't vote when the Constitution was written. We now certainly have the right to vote. So we have to look at the Constitution. Our job as Superior Court judges, however, is to apply the law. This is not to write the law as a Superior Court judge. It's to apply and interpret the law that's there. And in most cases, the law has already been written, so we're not. There are some cases where we're doing a first instance of interpretation, but in most cases that isn't the case. And in fact, what we are doing is looking at the specific facts because what you can do as a judge is apply the law to those facts to make a decision. So I think that we are not there to create new law and to have an agenda, but rather to look at the facts in front of you, make the decision based on that law. The law is not always the same as it was written by the founders, so there is some interpretation. Thank you.
I agree with both Mr. Hauser and Ms. Klein. First of all, the responsibility of a judge is not to go out and create law. It's just to interpret the law that's in front of you, using the existing authority that's in front of you, which includes the Constitution, both federal and state, and other compelling authority. The Constitution is an evolving document. It's been amended over 20 times in the course of the history of our republic. In addition, like Mr. Hauser says, you have to apply the facts of a case in relation to the Constitution. And the facts that a Superior Court judge may be confronted with in 2013 are not the same issues that would have been in front of John Marshall 200 years ago. So I agree that it's an evolving document, and it's done.
Thank you. I would agree in part with what my colleagues here have stated. The Constitution needs to be interpreted in light of the realities of the world that we live in. We know that GPS didn't exist back when the Constitution was drafted, but we do have to acknowledge that there is a process for amending the Constitution that is there for a reason, and that is to make sure that our Constitution remains a foundation that is firm and set, and that it's not just a document that is interpreted at the whims of a judge. It is not for the judge to just legislate from the bench and decide that they think the law should read in a particular way. And so from that sense, you have to acknowledge the stability of the Constitution as the foundation for all of our laws, for how we interpret every law, and how our cases have evolved over time. And to that end, it is not an evolving document absent the process for amending the Constitution, which our founders established. And so it's a little bit of both. You have to use common sense when you're interpreting it in light of the current situation, but you have to acknowledge the foundation and the importance of it. Thank you.
All right, and so you, Karen, this question actually came up from several audience members, and they asked to be very specific. Can you please discuss your Judge Pro Tem experience in Kitsap County?
Certainly. I've been a Judge Pro Tem in Kitsap County on and off over 12, starting in 2002, I believe was the time. I presided over all calendars. I presided over the criminal calendars, which would include motions and hearings and trials, also in Bremerton, Kitsap County District Court's Bremerton Municipal Court. I have presided over domestic violence calendars, anti-harassment, summary judgment, small claims calendars. Let's see what else. Jury trials. I'm going to make sure no small claims. I believe every calendar that's been presented to me, I have presided over in Kitsap County District Courts. I don't think there are any others. Domestic violence. I have also had civil and criminal hearings and trials, no context orders, land use, a variety of different issues.
Thank you.
I have 6 years of experience as a district court judge pro tem in Kitsap County District Court. All of that experience has been in traffic court. Thank you.
As I stated at the beginning, for the last 7 years, I've been a regular pro tem in Kitsap County. I pro tem in 4 different courts, one of which is in Gig Harbor, but 3 of them are in Kitsap County. I presided over jury trials, bench trials. I've heard civil cases, anti-harassment order, protection order, criminal cases, everything that there is to offer. I currently spend about a quarter of my time on the bench as a pro tem judge. I'm the most called upon, used pro tem judge in the county currently. Thank you.
In 2008 or 2009, I think I pro tem'd in Bremerton Municipal Court 2 times. Right now I work for the county, and I am not able to do pro tem work in any county because the county actually expects me to come to work every day. So that's my experience in Kitsap County as far as pro tem.
Thank you. Okay, so you, Rob, the question is, the United States has more people incarcerated than any other country. What initiatives can judges initiate or support to reverse this? Your thoughts, please.
Well, first of all, I think we need to keep in mind what this position is. We're running for a Superior Court judge. What we can do is limited. I do think approaches like that the Kitsap County Superior Court has used are very good. I think the drug court is a great approach to reduce the amount of people who get incarcerated, and also to encourage them to become productive citizens. There's a discussion about the Veterans Court. I think that's a great idea. So those are tools that I think that can be used to turn people around and make them productive citizens.
Thank you.
Thank you. I would agree with Mr. McDermott. The main way a judge can help in terms of dealing with this particular issue is by encouraging specialty courts that help address the core issues that cause people to commit crimes. We know that most of our crimes are committed because of mental health issues or drug abuse issues. When you're dealing with a non-violent felony, like a possession of marijuana or possession of cocaine, putting them through a drug court process helps reduce recidivism, helps reduce our costs for our jails, and is actually beneficial to our taxpayers in the long run if these courts are run efficiently. We can't dictate what the charges are that are filed. That's determined by the prosecutor's office. We certainly can't dictate all the sentencing ranges. That's been determined by the legislature. So what's really in the hands of the judge when a judge has the capacity to do is to encourage, assist, and promote these types of specialty courts that help address these core issues that get to the fundamental reasons behind crime and recidivism.
Frankly, there's not much more to add. Judges don't have the ability to take people out of prison. The law is very well dictated to judges about how they're going to sentence people. The therapeutic courts, however, are a very, very good program to get people, because of the bottom line, they work. People, it's a reduced recidivism. We have people that become more productive members of society. They can get a job. They're no longer drug addicted, or they're not actively involved in their addiction. One of the things that is at least being discussed, whether it's going to happen or not, is a truancy court. In the long term, if we keep kids in school, there's less likelihood that they're going to be involved in drugs or do other risky behaviors. We certainly have truants. We have a court that issues an order saying you have to go to school now. But a truancy court with a therapeutic court model may well help those kids stay in court, because there's a judicial officer that's actually active with them, making sure they stay in court, or in school. And if they stay in school again, they're more likely to go on to further education or training, apprenticeships, be productive members of society, less likely to do drugs or other risky behaviors. So there's some things like that that we can do. Thank you.
Our legislature passed the Sentencing Reform Act many years ago and put the goals of proportionality and punishment for adults. For juveniles, we looked at rehabilitation, which meant that more people received longer sentences, and that was the will of the people in the legislature in enacting those laws. That's evolved slightly to add more rehabilitation as an alternative in adult sentencing. And what's happened as a result of that is the evolution of some courts, because we see that studies have shown if you do treat the cause, such as drug court, then you will have success, lower the offender rate, stop the revolving door, and in fact, have more productive members of society and lower the cost to taxpayers. I was fortunate to be involved with the coalition involving more mailing in the first, I believe it was the first drug court in the country in King County working on that. I also support looking at mental illness courts and veterans courts as alternatives. Thank you.
Thank you. And this is somewhat of a follow-up question to that one in particular. And this question is, please discuss veterans and mental health and youth courts. So your thoughts on those specialty courts, I guess. Veterans, mental health, and youth courts. Jennifer?
I think I've touched on this a little bit, but I'll expand on my belief on these types of therapeutic courts, as I put it. Veterans Court, of course, is one that we are working on currently. I firmly support this as an option for our court system. It's proven, as we've stated before, that these types of courts actually reduce recidivism, that in the long run actually reduces the cost for the citizens, the taxpayers, and improves the lives of people who are going through the court system. This would be true of our mental health courts. We don't have a true mental, well, we have one in our court system, but we don't have one that's really global in a way that's going to assist most of our courts. It's one of the things that I hope to achieve as a judge in Superior Court is a regional mental health court. I think all of our courts, not just our Superior Court, but all of our local, our smaller level courts, our municipal courts and district courts, deal with mental illness on a daily basis in their court system. As a pro tem judge, I've seen it a number of times. And I think it's important that we have a court system that accommodates this issue and addresses it at a more fundamental level. With regard to youth court, I'm out of time, sorry.
Thank you. Bill?
Thank you. You know, in a lot of respects, I'm sort of a bottom line type of guy. Does it work or doesn't it work? And we found through the statistical studies of the drug court that we have in our community and also in other communities, veterans courts around the nation, they work. They protect the community. They hold the offender responsible. And they help that individual live a crime-free life. Not only that, but according to our local drug court office, over the last 5 years, there's another $10. According to our drug court office, over the last 5 years, they've saved about $5 million in incarceration. So not only do they, the bottom line is that it's working, but it saves us money. That's a bottom line type of thing that we have to take a look at and say, that's a successful program. We need to use those kind of jurisprudential models to be more effective in the other things that we do as far as the courts are concerned.
Thank you.
Follow up on my last remark, yes, I support alternative courts because they've been proven to be effective. We have veterans returning from 5 tours of duty. It's not surprising they have mental health and drug issues, and we need to treat those issues to stop the revolving door. We're fortunate also to have a senator who is in charge of veteran affairs, and I think if I'm elected, I would like to work with her as I have working with seniors and veterans now in my business to see if we in Kitsap County can get some of the funding, because all these courts take initial outlay of money, and it's all well and good to say we want things, but of course our county is strapped like everywhere else, and we have to be more efficient with our funds. So we have to look for ways to fund these programs which have been proven successful. Youth courts, we know that if we can work with children and offenders and give people positive role models. I've been a mentor and I see what happens. And when you do mock trials and you give people alternatives and teach them and show them that there are alternatives and that they can get treatment for their diseases, then we can stop that door. Thank you.
I believe in the concept of redemption. If you have the opportunity as a judge to intercede in someone's life and to give them an opportunity to take a new path, find a new direction, to become a productive citizen, then I think that's what should be done. And these therapeutic courts address that issue.
Very good, thank you. And we wouldn't have an exit issue if we didn't address private property. So with that, I believe we start with this question goes to you, Bill, for starters. If economists are correct that private property is the basis of a sound economy, what is your understanding of private property rights and regulatory taking?
Wow, that's a broad question to be answered in a minute, that's for sure. As I understand it, the government can establish zoning laws. I think that's pretty clear. But the eminent domain provisions of our government still remain in effect. So if, in fact, government takes your private property, they have to pay for it. I think that's pretty clear. All of us have. I assume that most of us here have private property. We don't have homes, or at least buying our homes. I like my property to be undisturbed by other people unless I give them permission. I think everybody else does too. The law is going to be followed by whoever is elected to this position, and we'll deal with that law as it comes up. Beyond that, I probably could write a blog review if I wanted if I studied long enough, but thank you.
Thank you.
We have a Fifth Amendment that allows for taking, no taking without just compensation and the right of eminent domain. And in each case, what a Superior Court judge is doing is looking at the facts. And often we're dealing with land use issues and an appeal of a land use issue from a hearing examiner's decision. And so we need to look at the facts. You can't give a blanket statement. It's about looking. And is there a taking? And if there is a taking, was there just compensation? And was the taking legal? So there's various facts to say, do we respect private property? I own property. I understand the issues around someone's concerns. We can zone property. The government has deemed and the legislator has deemed that it is appropriate in certain cases to take property for the good of the community and the citizens, and if so, then you must be compensated. It's not our job as judges to decide that we don't like the law. It's our job to apply the law. Thank you.
Well, the U.S. Constitution protects private property, and but the government does have the right of eminent domain. Early in my career, when I was at the Shires firm, I was actively involved in probably at that point the largest eminent domain case in this county. It was involved when Kitsap Transit condemned the Menor Bus Company, and I played an active part in that case. As far as addressing specifics, as a judge, as a candidate for a judicial position, we're ethically precluded from addressing specific issues. And these sort of issues may come in front of us. So I think we need to understand the context of the question. And then, again, we are ethically precluded from addressing them because they may come in front of us. So that's the best answer I can give you.
The last 9 years I've been working as a land use attorney as part of my private practice work and my work in the county. I'm familiar with both sides of this issue, from both the government side as well as private property owner side. One of the issues that was asked, which was not addressed by anybody up to this point, is the question of regulatory takings, and when does that occur? The law states that regulatory taking occurs when the government deprives the property of all economically viable use for that property. And under those circumstances, our law dictates that the person be compensated for the loss of the use of their property. This is a line that seems to move from case to case. It's not always clearly defined. It's going to be on a case-by-case basis as you look at the property, you look at the uses, you look at what's left after the regulations. Our regulations that we have under our government can deny all economically viable use, but there is a presumption that they will not be denying it. And so this is obviously a balancing act. I agree with my compatriots here that this isn't about what we believe the law ought to be. This is what the law is, and this is what we'd be obligated to enforce. Thank you.
And now getting into a question of background, and it starts with Karen. The question is, should a Superior Court judge be an expert on any particular type of law, and if so, what?
It would be nice if we could be an expert on everything, but the reality is we can't be an expert on everything. The court, 60% of the cases you hear are criminal law. I have a substantial background in criminal law. I've been a criminal defense lawyer for over 20 years and have tried every kind of case representing individuals facing the death penalty to simple assault to complex economic crimes. But can we be an expert? No. But being general counsel, which I was, and which I also am now for my own company, is like being a Superior Court judge in that you don't know what's coming in the door. So you have to be ready, and what you want from a judge is someone who is smart, who is going to work hard and study the laws and learn them. We can't be an expert on everything. There's nobody who can be, and even people who do only criminal and face a criminal calendar don't know every criminal case because it's based on the facts. And the law changes, the facts of each case change, and so your decisions are not one that you can say, oh, I know what the answer is, and it's going to be the same for each case. Thank you.
Thank you.
Well, that question seems to, suggest should a judge be an expert on everything? Sure, but every kid should eat his vegetables and clean his plate, and that's not a reality. And there's no one who's going to step onto the bench who's going to be an expert in every area of the law. I think the key is to have the intellectual horsepower, be able to understand the facts that are presented to you in a case, in the law, and to use your intellectual abilities to arrive at a just and fair decision.
Thank you.
I agree that a judge cannot be an expert on every area of the law, but I think there are certain things they I'm close to an expert on. I think Superior Court judges should be an expert on the rules of evidence. I think a Superior Court judge should be very familiar with criminal law and have an understanding of general civil litigation rules. If they can't do this, they're going to be scrambling from day one to handle any of the cases that appear in front of them. These are just foundational requirements for this type of work. Beyond that, I agree this is an area where you're essentially the last general practitioner that there is. A Superior Court judge will hear everything from a homicide case to a complex contractual dispute. The reality is you need judges who have the intelligence and the ability and the skills to adapt to all the various legal issues that are presented to them. I've been practicing for the last 16 years in both criminal and civil work currently in Superior Court. I'm familiar with these rules. I understand both sides of these legal issues. I'm also a municipal attorney, which, similar to this client, puts me in a position of handling a variety of issues on any given day, ranging from employment issues to land use issues and amount of time.
Well, I agree that there is one area of law that a Superior Court judge needs to be an expert in, and that's the rules of evidence. Because the judge in a trial level court is the gatekeeper of evidence. Lawyers are attempting to get evidence into the court by asking questions or introducing documents or exhibits. It is the judge who says you've met the rules or you haven't met the rules. And so the judge has to be an expert in the rules of evidence. And I don't believe that a judge at the trial level can be an expert in almost anything else. But of one thing, the rules of evidence, that's the one area that the judge has to be an expert in.
And moving on to our next question, and we'll start with, this one goes to Rob, for starters. Does political partisanship have a role in your decision making, and should it?
Oh.
I think I've been quoted saying this time and time again that justice is nonpartisan. You come in front of me as a judge, it's not going to matter to me whether you're a communist, a libertarian, a Republican, a Democrat, or anything in between. The reality is that the law applies equally to you regardless of your political persuasion. It is really imperative that candidates be balanced in their approach to things, and I'm actually quite honored to be endorsed by both Republicans and Democrats, which is something that I work to achieve, to demonstrate the balanced approach that I believe a judge should have when they run for office.
Thank you.
I could answer that either the way Rob answered it, or the way Jennifer answered it. Let's just say, I'll take Rob's. No.
Very good. Karen.
The short answer is no. A little longer is that we all come with biases. It's our experience and our life experience and our abilities to set aside those biases and make rulings based on the facts and the law before you, so that everyone has an opportunity to be heard, that makes someone suited for the bench. You should not be bound by anyone. I have support from all sides, but it doesn't matter because people are electing you, not because I am not going to be a judge because I have a platform up to preach to anyone. It's about being fair, and it's about having the experiences as a lawyer and in life, and the maturity to learn to be more culturally competent and inclusive to all, that makes someone a good decision maker. Thank you.
Thank you. All right, and to you, Jennifer, the question is, do you believe that applying case law or precedent in foreign courts is appropriate in U.S. courts?
If I'm understanding this question correctly, we're talking about foreign being out of the country versus foreign being in another state or another jurisdiction. At this point, I believe that our courts need to make decisions based on our Constitution and our legal precedents. Is it possible to learn something from how another court has done something? We call that persuasive authority. You might read a case from France, or read French, or from Canada or wherever, but it's not binding. It's not going to dictate how an outcome occurs in our court system. It might give us some guidance in terms of legal reasoning that maybe hasn't occurred in our jurisdiction before, but that's the best it can be used for, what we would call persuasive authority. So no, I don't believe it should be used as precedential authority.
Bill?
What she said. Actually, as she was speaking, I wasn't listening to her because I was trying to think of where in the world would I actually try to apply a foreign case law. And the only thing I can come up with, if the parties in a contract have bound themselves to contractual agreement that they're going to be applying the law of Canada, for example, in a contract, and it happens to be here in Kitsap, I suppose maybe that's where you do it. I can't imagine another way. Thank you.
We have to follow the law that's relevant to the case, and that's generally not foreign law unless there is a contract stating that foreign law applies. So you're going to look to the Washington Supreme Court, then the Court of Appeals. You're going to look to the federal courts if that's relevant to what you're having, but what is relevant to the case. But we're not going to rely on foreign courts because we have law here to tell us and guide us in terms of what the law is for each case.
Well, I find it hard to imagine Kitsap County Superior Court judge would ever be confronted with having to a case in front of them where they have to look outside the United States and find authority. Courts follow a hierarchy of authority. The Constitution of both the United States and the state of Washington, statute, what we call compelling authority in the form of common law decisions that are compelling for the jurisdiction that you're within, and then you look to cases outside your jurisdiction. If you can't find a case within the 50 states of the United States, I just can't imagine that coming up. So the answer is no.
Thank you. So the next question is, and I believe this starts with Bill. The question is, and this is a broader question, not specific to the judgeship position, but the question is from our audience member who asked, what can be done to keep drunk drivers off of our streets?
Boy, I love the questions. I get to go first. So I don't know whether there's any way you can keep someone from over-imbibing in either drugs or alcohol and getting in the car and driving. Then you just can't do it. Let's just stop the sale and production of alcohol and drugs and make sure that nobody has access to it. But even prescription drugs can be enough to get a driving under the influence. So how do you do that? Boy, if I had the answer, I'd be really a whole lot more valuable. I don't know.
Thank you.
Well, I don't know of any country that's found that answer, any community that has. We have, our legislature has enacted laws to make it tougher, and they continue to do that for crimes such as vehicular homicide as well as misdemeanors of driving under the influence. We have passed laws in our state recently to privatize liquor sales. That's yet to be seen whether that will increase or decrease the use of alcohol. There isn't, we're running to be judges, not to be legislatures, and those are the branch of government that's going to set the policies and write the laws that can hopefully solve those problems. I don't have, I wish I had one answer to stop that because we all know the devastation that's caused in alcohol.
I think the solution lies outside the legal system, quite frankly. The legal system is doing the best job they can to deal with the issue. I think it's a cultural problem that has to be addressed through education and programs like MAD. One thing I remember is that the Navy's had a huge sea change in dealing with alcohol issues. When I was on active duty, being drunk was a defense to something. But over the last 30 years, the Navy has changed that. And they hammer guys when they get in trouble with alcohol. I think what MAD has done has been good. So the solution is outside the legal system. It's not within the legal system. The legal system is doing the best it can to address the problem.
Thank you.
I agree with my opponents here in terms of the fact that this is really more of a legislative issue than a court issue in a lot of ways. One of the things I've heard suggested, which is somewhat intriguing, is the idea of putting ignition interlock devices on all cars out of the box that come out when you buy them. So everybody can't drive a motor vehicle if they've been consuming alcohol. But that's not a decision for the court to make. That's not something that I, as the court, since person on the bench can dictate. I can, however, as a judge, and I have as a district court and municipal court judge, pro tem, determined conditions of release on people who are in front of me. And what you have to do is you have to weigh their prior history, you have to weigh the circumstances, you have to look at all the facts in front of you and determine what kind of conditions of release you can put on a person. Beyond that, you can do, again, things like therapeutic courts and deferred prosecutions, which encourage treatment, because really the only solution to preventing drunk driving is either not letting them in the car in the first place or ensuring that the people who have an alcohol issue have opportunities for treatment.
And now for wrapping up as we get close to the end of our question and answer period. This question is a little bit more personal because it asks, and it goes to start with Karen. How do you think you personally will impact the Superior Court bench? How will you think you personally will impact the Superior Court bench?
Well, I think that's for the rest of the public to decide how I'll impact it. I believe I will make a difference on the court. I bring maturity, I bring life experience, I bring business experience, and I bring legal experience. And I think my personal impact will be able to look outside the box. I run a company, a startup company, so I've learned how to find solutions doing more with less, not just in staffing and raising capital in our Kitsap County, but in looking outside for solutions. And our community is at, one of the biggest problems is funding, and so how do we find solutions? So we want to look at ways that perhaps our court is doing a great job. So one of the things I bring in impact is bringing a fresh perspective to the court, both from my innovative approaches as well as my diverse experience. In addition, I have taught nationally on social media and the legal risks and rewards of social media, and I believe that I have to do more with education to reach out because we serve the public.
Thank you.
Well, I think the thing that I would bring to the bench is life experience, a substantial amount of life experience, both as a lawyer but outside the law. And I think that's what equips me to take on the job. I think not only have I been a lawyer, but I've owned a business, and I worked in the real estate industry when it was going through its hard times. So I think that collective experience, that being a father who's raised a family, I just think that's, is what gives me the ability to go and listen to people's cases and to try and reach a fair and impartial decision.
Being a Superior Court judge is a privilege and a obligation where you are truly a public servant. When you put on the robe, you take the bench and you are serving the public. What I would bring to this role is I have the intelligence, the energy, the work ethic. I understand how it works when a judge doesn't read briefs, doesn't do their homework, and puts people who pay good money to their attorneys to appear in front of them, and then they simply go to court and have nothing happen because the judge didn't do their job. I bring that to the bench first and foremost. The second thing I bring to the bench is longevity and stability. In the next 10 or 15 years, practically our entire bench is anticipated to retire. And what I provide is the next generation of judges. I will be on the bench for a good 20 or more years, and I'm looking forward to bringing that longevity and stability to the court. Thank you.
The mandate of our Superior Court is to resolve cases. People are suing each other, the states file criminal charges, whatever. There is conflict. People are in conflict, and the mandate of the court is to resolve that conflict. I will bring an attitude to join 7 other judges as a team of judges there to resolve the cases before it. Get the job done. As I said, I'm a sort of a bottom line type guy. You got to get the job done. You've got to get in there and do what it takes to resolve the cases effectively, efficiently, and the lowest cost possible. I also believe that I have longevity because I have 9-year-old twins, and so I'm going to be working for a long time. But I will say this, I'm running for a 4-year term, and the people after 4 years, if I'm elected, will decide whether I get another 4-year term. And so my longevity, if elected, might be 4 years, or it might be longer than that. That's what the people of this county get to decide. So thank you very much.
Last question, and this is actually a hypothetical case model. I believe the individual asking this question is just wanting to hear your application of law and thoughts on this hypothetical case. Please bear with me, it's relatively long. So the question is, while sitting at home on Saturday morning and channel surfing after years of suspicion, the Roadrunner sees the video evidence of Wile E. Coyote trying to get him. Does he have evidence enough to put a restraining order on said coyote and to file a suit on Acme for damages of $10 million? Bill, you complained earlier. Yes, sir.
Oh, sure.
Would you like to
Well, first of all, as I said before, judicial candidates are ethically constrained from addressing issues that may appear in front of the court. I will say here, though, there's a threshold question: is where is
Wile E. Coyote?
Coyote? I would presume that he's in a jurisdiction outside of Kitsap County. So really, the question is moot. Thank you.
Jennifer?
On a more serious note, I think Wile E. Coyote's been out to get Roadrunner for a long, long time, but evidence from the television is not evidence in court. And what's important in terms of looking at this from a serious perspective is the fact that you have to have evidence that's admissible in court in order to get a restraining order, in order to file a lawsuit. Now, if Roadrunner subpoenas the information from the TV station or obtains substantive and admissible evidence in court, Roadrunner may in fact have sufficient evidence to pursue a restraining order and/or a lawsuit. I'm not sure about the value of the lawsuit. I'd have to have a little bit more information, but it seems like there's some evidentiary hurdles that the Roadrunner's going to have to get over.
Yeah. Okay. Yes, restraining orders. You know, as Jennifer says, there are certain evidentiary issues that you have to deal with restraining orders. But restraining orders, in certain circumstances, are pretty easy to get because it does just take an affidavit of the party that's been heard. So probably a temporary restraining order would be granted. Whether the permanent restraining order would be granted, I don't know. As far as the damages, I don't think Roadrunner's damaged at all. At least, if I was a witness describing what I've seen in the Roadrunner's activity, I think the countersuit might be better.
As a judge, you can only decide on facts. Whether if someone were to come to court, you can get a temporary restraining order based on an affidavit if there are sufficient facts to warrant it. And based on a television, perhaps not. We need to look at, is there a pattern? Has there been contact? What is the harm? What is the danger? Saying someone's out to get you may not be sufficient since we're dealing with a hypothetical. Once a preliminary restraining order is granted, if a judge finds that correct, then the parties have to be served, which might be quite difficult here, to serve Wile E. Coyote. And then you have to look at, is that, should a permanent one be granted a permanent restraining order? Is there a fact that this is going to continue? Based on the hypothetical, there is not sufficient evidence. That's all that was presented to the court of damages. Thank you.
Thank you. Well, thank you very much. That concludes our question and answer period. I just want to remind you all that next week, Tuesday, there will not be eggs an issue. There will actually be a general election. And I hope that you will get the vote out and vote accordingly. The following week, which is the August 14th, we'll begin the Mano Mano 101. And with that, we'll have... Yes.
That one's canceled. There's only one person running for that office, so we have 2 week layoff until 21st.
A 2 week? I get a 2 week vacation. Holy moly! Oh, thank you very much. I just got. Thank you for the benefit. But with that, we are now going to conclude. The candidates are allowed 2 minutes to give a summary of their experience, re-answer any questions they'd like, whatever they'd like to share with you, the audience members, as you go into the elections next week, Tuesday. And we started with Jennifer, and this then goes to Bill for summary.
that's when we do these type of forums. We've done a number of them. We often talk about the types of people or groups that have endorsed us during the course of the campaign. And so I'm going to spend my last 2 minutes talking a little bit about that. Early in the campaign, I was very pleased and proud actually to receive the endorsement of the Deputy Prosecutor's Guild in this county. And I find that professionally as well as personally pleasing because they are the people that I am opposite every day in court. They are the people that prosecute the cases, and I'm one of those people that defend the cases. So to have my adversaries in court come to me and say, Bill, you're the one that we're going to endorse was very, very personally as well as professionally pleasing. But recently there have been some changes and some endorsements. For example, the Kitsap Sun recently endorsed 2 of us in this race, Mr. Forbes and myself, to go on to the next level. So did the North Kitsap Herald. So again, having that joint endorsement also has been very pleasing professionally as well as personally. And then just last week, the Kitsap County Bar Association did a preference poll, and I'm very pleased with the fact that I received the most first place votes out of that group as well, with 53% of the first place votes. I also was named on, my box was checked on the most ballots. We were able to choose first and second place, and so I received 89 votes out of the 97 that were cast, either first or second place. So that gives you an idea, again, as Ms. Forbes said, it's not necessarily we want to rubber stamp, it gives you an idea of the different levels of people who have taken a look at the candidates, me personally, the other candidates personally, and decided that we're going to go and endorse or choose this candidate over another. So, and then one other thing, and I'm sure everybody here in the front table is tired of this, but early in the campaign we do kickoffs, of course. And the kickoffs, mine was on Bainbridge Island. I want you to know that out of that kickoff, my 9-year-old twins formally endorsed me and have yet to revoke that endorsement, so I still claim it. Thank you.
Well, I've told you a lot about my diverse legal experience, but what I want to tell you a little bit about are a couple of things, which are some of the accomplishments I've been most proud of. One of the things we want to do is increase access to justice. I'm proud to say that I was active in having passed the motor voter bill way back in the 90s, and it was about increasing access so that people are not voters just based on their property rights, but rather their driver's license, to be more inclusive of everyone. And that also includes who serves on a jury. And that shows my commitment to increasing access. I've been a firm believer in increasing access. We have huge problems with pro se litigants, and increasing access through education. I've been a nationally known called upon speaker on issues of social media. I've spoken on ethics to the Washington Association of Elder Law Attorneys. And I bring a different perspective to the court because of my business experience. I would also tell you I'm most proud of being awarded the National Law Journal's Pro Bono Award as part of the Innocence Project Northwest, which was a national award I received for my work as doing an appeal. My diverse experience shows you that I have ability to be inclusive, to understand the needs of the business community. I work with seniors. We have an aging population, and more aging issues will come before the court, whether it's guardianship, elder abuse, custody issues with grandparents and grandchildren. And I bring a perspective that's different based on my work in Kitsap County on aging issues and the legal ramifications of those, which we'll see in the court. So I would ask for your support based on my diverse legal, business, and life experiences. I'm 54 years old and believe that I have the appropriate demeanor and abilities and ethics to be an excellent judge. Thank you.
Thank you.
Again, whatever metric that you use to measure experience, I have more. I have more experience as a lawyer. I have more experience as a judicial officer. And I have more life experience. I think those are all critical to be an exceptional judge. In addition, I have shown throughout my career that I have the intellectual horsepower to do the job. Now, I cannot top Mr. Hauser's endorsement for his 2 9-year-old twins. And trust me, I'm going to go after those endorsements later on. But I am proud to, in addition to the endorsements of Sheriff Steve Boyer and Bishop Larry Robertson, one thing I'm proud of, I've been endorsed by My ex-wife, and she co-chairs my campaign. How many of you can say you've been endorsed by your ex-wife? And so I think that speaks to my background too, so thank you.
What's important in a good judge is that they have the right demeanor, the right intelligence, the right work ethic, the right skill set to be a good judge. It's not how old you are, it's not how many years you've been practicing, it's whether or not you have these core skills that make you a good judge. I stand here today endorsed by nearly 400 people, including 19 judges, 17 of them your local judges. These are judges who know the needs of our court and who know all 4 of us who sit up here today. I received 81 of the votes out of the bar poll, so I'm just slightly behind Mr. Hauser on the bar poll, but I'm also endorsed by my opponents in legal issues and a variety of other attorneys throughout the community. What this tells you is not that I should be rubber stamped as the right candidate for this, but those who know me know that I have the skills for this job, who know that I am the right candidate for this position. These are people who know that I'm going to be a good judge, and I have been honored to be the most called upon pro tem in this county for the last 7 years because I have demonstrated these skill sets. I don't just talk about them, I've demonstrated them on a daily basis in our local courts. And I am honored to have that role and honored to have that position, and I look forward to serving our community in that same capacity in our Kitsap County Superior Court. I appreciate it. I hope to have your support. Thank you.